well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam & Company. My name is Cam Edwards. I'm so glad you're with us on the program today. We got a busy one for you. You know, it is the last show of the week, so we're going to do double duty. We got a couple of different stories to chat about. Michael Graham going to join us here in just a moment or two. He's the managing editor at New Hampshire Journal. We'll talk about Maggie Hassan, the senator from New Hampshire, Democratic senator from New Hampshire, who earlier this week was apparently on the fence about the nomination of David Chipman as permanent director of the ATF, but has since landed. She's come off of the fence, and she has landed squarely on the side of anti-gun activists, which is not necessarily shocking, but could pose some problems for her in her re-election campaign next year. We'll be taking a look at what is going on in the Supreme Court, where the first round of court briefings are in. More are on the way in the case New York State Rifle and Pistol Association versus Bruen. This formerly known as New York State Rifle and Pistol Association versus Corlett. This is the case that the Supreme Court's going to be taking over the fall, dealing with New York's subjective may issue carry laws that require you to demonstrate that you're special, you're different, that you somehow have a need elevated above that of the average citizen in order for you to exercise your constitutional right to bear arms. And I know a lot of gun owners are eagerly anticipating the court taking up this case, which I really don't think would have happened were it not for President Trump making these nominations, putting, folks like Amy Coney Barrett and Brett Kavanaugh and Neil Gorsuch on the bench. If Democrats were in charge of controlling the court and appointing nominees over the last 4 years, we would have a very, very different Supreme Court. And gun owners would likely be shying away from a Supreme Court fight rather than eagerly anticipating one. All of which is to say, do you miss President Trump? Because a lot of people do. And I'm coming to you with a very special offer that you do not want to miss. Now's your chance to win one of 6 signed photos of President Trump, hand-signed by President Trump. And soon, one could be hanging up in your house. When President Trump signed these photos, he wanted to make sure that all of his supporters had the chance to receive one. And now is your chance. All you have to do is text CAM to 55404 today for your chance to win a beautiful photo of President Donald Trump, First Lady Melania Trump, hand-signed by President Trump himself. By texting CAM to 55404 right now, you'll actually get exclusive double entry activation for a limited time. Again, text CAM, that's C-A-M in case you need to know, CAM to 55404 to have your name entered twice to win a hand-signed Trump photo. You don't want to miss this. Contest ends soon, paid for by the National Republican Senatorial Committee. So let's turn our attention, speaking of senators, let's turn our attention to one of the Democratic senators from New Hampshire. One of 4 red state Democrats that Politico had said was still undecided about what to do with the nomination of gun control activist and former ATF agent David Chipman to head up the nomination, or to head up the agency where he once served in the department. John Tester of Montana, Joe Manchin of West Virginia, Angus King of Maine, who is an independent but caucuses with Democrats, and Maggie Hassan were the 4 Democrats that Politico mentioned. Apparently now there are 3 who are publicly undecided because New Hampshire Senator Maggie Hassan says that she is, yes, going to support the nomination of David Chipman. We had a chance to talk about it with Michael Graham of New Hampshire Journal. Take a look and a listen. Michael, thank you so much, sir, for coming on the program. It's good talking with you today.
I got to tell you, this is as close to that beard as I want to get. Sam. I got to be honest, it frightens me. It absolutely frightens me.
Just for that, I'm going to drive up to New England just to say hi in person. Give you a big old hug, just rub it right all over your face there.
It's amazing. Amazing to me.
I actually am kind of interested in going up to spend some time in New England. I would love to, honestly.
The face of the U.S. Senate could very well hang in the little purple state of New Hampshire.
Exactly. I don't know if Chris Sununu wants me up there on the stump right now, but I will say, I think the Second Amendment is going to be a big issue in next year's Senate campaign in the state. Maggie Hassan coming out and endorsing David Chipman as director of the ATF. Were you surprised to see this, Michael?
I'm no longer surprised by Senator Hassan. I don't mean that in a negative way. I just don't understand what she's doing. Because on the one hand, she's broken with the party on occasion. For example, during the, remember that Votorama they did for the last reconciliation? there was a proposal to give the COVID relief checks to illegal immigrants. And she was one of 8 Democrats who broke with her party. But at the same time, when she was in the legislature in New Hampshire, she posed a ban on sanctuary cities. In other words, she fought to keep sanctuary cities in place. And again, when it came up in the U.S. Senate, she was there with it. And so she's all over the map. I thought, for example, there was no way that the HHS secretary, Javier, I'm spacing his last name.
Becerra.
Becerra,
Yeah.
thank you. That she was going to open. I'm like, this guy's so extreme. He said so much crazy stuff. He wanted to force nuns to pay for birth control. She had no problem. She voted for him. And yet, she's part of the infrastructure moderation deal. And it's funny, we have a running gag at nhjournal.com about the number of times she sends out press releases with the word bipartisan in the headline. And it's like, in one day, she had 4 press releases that all had bipartisan in the headline. But she doesn't vote bipartisan. Her voting record, and I don't, by the way, neither does anyone else. In other words, is she bipartisan compared to people who vote 99% with the party? Yeah, because she votes 92% with the party. But, so the Chipman thing, on the first glance, you're like, no, just don't vote for that guy. Why give the Second Amendment community yet another reason to distrust you? They already distrust you because you're a Democrat. They already distrust you because you sound a lot like a progressive a lot of the time. Here's an easy one. This guy's not, he's problematic. A lot of other people, Senator King next door in Maine has a problem with him. She didn't have to come on board, and yet she jumped right in, and it's yet another thing like the HR1, the voting takeover bill. She could have easily just said, no, I'm with Joe Manchin on this. I'm not doing that. She's 100% in. So it's really a level of political schizophrenia. And as a guy who used to run campaigns for a living, whatever you think of the policy, good or bad, I don't get the strategy. That's why was I surprised? I'm too confused to be surprised.
Yeah, I'll be honest with you. I don't really get the strategy either. I mean, she narrowly won her last Senate campaign, and I do mean, it was about 1,000 votes, right?
Exactly. It was, I want to remember, it was like 1,056. I think I may be off by one digit there.
Yeah.
And in fact, it's such a tiny sliver that the activists on the left who organize campus voting, every time they get 1,050, whatever that number is, new registered college students, they call it the Hassan. So it's like, we got 3 Hassans at UNH last month. So that's how narrow the margin was.
Yeah, absolutely. I mean, and I know she's doing well in terms of her fundraising, but New Hampshire is a very Second Amendment friendly state. You all are a constitutional carry state. Right. And it seems to me like, she has just invited this now to be a primary issue in her reelection campaign next year.
And as well it should be, and it is absolutely going to be. And it's funny because we've got a piece coming out of NH Journal later today about this very issue. And when I talk to the gun advocates, the number of votes that she has that are problematic is relatively small because, part is because stuff just didn't come up that often, but she has a couple of votes. But my point is, she wasn't in a spot like, Blumenthal in Connecticut where, she was kind of there and you got to own it. She has lots of maneuvering room. This was an easy one. This isn't opposing the, ban on semiotic weapons that scare people, whatever they call the assault weapons
right.
ban. This was one that no one was going to say, oh my gosh, how could you not stand by Chipman? No one knows who the heck Chipman is. But yet she embraced it early, up front, and as far as I can tell, for no good reason.
Yeah, again, talking with Michael Graham, managing editor at New Hampshire Journal and Inside Sources as well. Michael, listen, I do appreciate your insight. I know we're going to be paying very close attention to this race going forward, but thank you very much for your time today, sir.
You have been writing about a piece in one of our Inside Sources products in Philadelphia, the Delaware Valley Journal. And one of the things I love to point out to people about New Hampshire, it has the 3rd highest rate of gun ownership in the country. 3rd highest. It has the lowest homicide rate in the country. Now, sometimes it bumps from 50th to 49th. It's kind of like, but it is always one of the lowest. And every time someone says to me, as the Biden administration is saying, guns are crime, that's their strategy now to address crime, because there's a crime problem. No one disputes a crime problem, but they don't want to deal with crime, so they're going to deal with guns. Every time they say guns are crime, I just say 2 words, New Hampshire. Explain to me how so many people can own so many guns, and yet it is literally most years the safest place to be if you don't want to get killed. unless you're married to my wife. It's not particularly safe at all. Fortunately, she does not own a gun.
We're going to leave it there before you put your foot in your mouth any deeper there, Michael. Michael Graham, thank you so much for coming on the program, sir. Let's do this again very soon, shall we?
Anytime.
All right. We will see what happens here with the Chipman nomination. Obviously, it would have been great if all four of these moderate Democrats said no. But Hassan, I think, is the one who is at least had the most history of supporting gun control in the past. I think ultimately this is going to come down to Joe Manchin of West Virginia once again. I suspect if I had to place a bet today, my bet would be that Angus King comes out and supports Chipman's nomination, even though his fellow senator from Maine, Susan Collins, moderate Republican, has come out and opposed Chipman's nomination. I also would bet, if I had to right now, that Montana Senator John Tester would also end up backing Chipman's nomination. Tester, portrays himself as a pro-gun Democrat, but when push comes to shove, he tends to align with the party. So we'll see what happens. But again, if you are a gun owner in Maine, West Virginia, Montana, frankly, no matter where you live, you should be contacting your senators and urging them to oppose the nomination of David Chipman. Now, let's turn our attention to our second big story today, and that is New York State Rifle and Pistol Association versus Bruen. The case of the Supreme Court is going to be taken up in the fall. We don't yet have a date when oral arguments are going to be held. The Supreme Court did release a calendar of oral arguments for October, and New York State Rifle and Pistol Association versus Bruen not on the list, so it's probably going to be a little bit later on in the fall. But again, already the briefings are starting to come in. This is exciting if you're a Second Amendment legal geek. You don't even have to be a Second Amendment attorney, just a legal geek, a legal aficionado, and you can be excited about this. So here it is. If we're in the Supreme Court of the United States, this is the petitioner's brief filed just a couple of days ago by Paul Clement, the counsel of record for the plaintiffs. And the brief itself, again, this is the argument as to why New York's carry laws should be struck down. So let's take a look at some of their arguments here. First, Clement says New York's regime. Well, actually, this is not first. I'll read you how this actually begins here, and then we'll go through a couple of the highlights. But the summary of this case actually starts with a recitation of the question that is posed: whether the state's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. Now, again, keep in mind, that's not the question that was originally posed to the court, but that's the question that the court decided to answer, which is a little bit narrower of a question than what was asked by the plaintiffs originally. The state of New York also, by the way, had a different question that the court rejected as well. But the court seems to be focused in on whether or not the denial of concealed carry licenses violated the Second Amendment rights of New Yorkers. And as this brief points out, look, there is no open carry allowed in New York State. So getting a license is, in essence, the only way for New Yorkers to exercise their right to bear arms outside of the home. And as the brief says, New York's regime is irreconcilable with the text, history, and tradition of the Second Amendment. Note, by the way, that phrase, text, history, and tradition of the Second Amendment. One of the arguments that the court is really going to be dealing with beyond the issue of carry licensing in New York itself is what standard of review should be used when looking at the constitutionality of these gun control laws, because the court has largely been silent on that. You've got lower courts that have adopted this standard of intermediate scrutiny for the most part, which is this sort of vague, fuzzy middle ground, legally speaking, that, as long as the state has a good reason for violating your rights, they can do so. They can get away with it. And here you've got Paul Clement arguing, no, that's not the standard that should be used. And under the standard that should be used, New York's law is unconstitutional. The textual inquiry says is not a close question, as the text guarantees a right to bear arms as well as keep them, and a right to bear arms only within the confines of a home offends both common sense and original public meaning. The historical inquiry is no closer and has already been answered in Heller. Founding era cases, commentaries, and laws on both sides of the Atlantic, most of which were surveyed in Heller, confirm that the founding generation understood the Second Amendment and its English predecessor to guarantee a right to carry common arms for self-defense. The American tradition of protecting that right remained virtually unbroken in the century and a half following ratification. Severe restrictions on the right to carry arms typically arose only in the context of efforts to disarm disfavored groups like blacks in the South and immigrants in the Northeast. Those outlined in discriminatory efforts only underscore the framers' wisdom in enshrining the right of all the people to keep and bear arms in our founding documents. So immediately a broadside launched against New York's Sullivan Act, which was put in place in 1911, and yes, really was designed to prevent immigrants to this country from being able to carry a firearm for self-defense. This was a discriminatory law on its face more than 100 years ago, and I'm really glad to see Paul Clement bringing this to the forefront of his argument. He goes on and says, because text, history, and tradition confirm that the Second Amendment protects the right to carry common arms, like handguns, for self-defense, the state cannot flatly prohibit law-abiding citizens like these petitioners from exercising that right. That was the lesson of Heller. Indeed, he says, Heller likened the District of Columbia's unconstitutional ban on possessing handguns inside the home to, quote, severe restrictions on carrying common arms outside the home. Like the district's regime in Heller, New York's regime effectively criminalizes the exercise of a fundamental constitutional right. Just as the district's extreme regime could not survive any meaningful form of scrutiny, neither can New York's effort to let only the few exercise a right that the Constitution secures to all. So one of the arguments that the state of New York is making is that, look, you can go back and you can find laws restricting or even banning the concealed carry of firearms back in the 1800s. Like, that wasn't unusual. So why is it unusual for us to have a law in the books that requires applicants to show good cause or a justifiable reason to carry a firearm and to have that approval signed off by a county sheriff or a judge? How's that unconstitutional? Look at what happened back in the 19th century. Well, Paul Clement takes these arguments on with a little history lesson of his own. And he points out that most of the courts that upheld those restrictions on concealed carry did so while acknowledging that individuals could openly carry a firearm. In fact, he said, quote, even courts that approved concealed carry laws reaffirmed the right to carry arms. They just found that the ability to carry openly was sufficient to protect it. And then he cites a case out of Alabama in which the majority wrote, the legislature cannot inhibit the citizens from bearing arms openly because the Constitution authorizes him to bear them for the purposes of defending himself and the state. And it's only when carried openly that they can be efficiently used for self-defense. Now, that's from 1846, holding that a prohibition against bearing arms openly was in conflict with the Constitution. He then points to a Louisiana case from 1850, holding that restrictions on concealed carry were permissible only because Louisiana guaranteed every citizen's, quote, right to carry arms in full open view. Clement says, indeed, the only cases that cast doubt on the right to carry arms were later cases that relied on the mistaken premise that the Second Amendment and state analogs did not protect the individual right to keep and bear arms for self-defense. He continues with his history lesson post-Civil War, saying the widespread agreement that the right protected a right to carry arms outside the home for self-defense continued into Reconstruction, quote, as people debated whether and how to secure constitutional rights for newly freed slaves. The newly liberated citizens faced waves of terror across the South, emboldened by ordinances prohibiting them from carrying arms for self-defense. For instance, he writes, an 1865 Mississippi ordinance, quote, that would serve as a model for the black codes of other southern states, declared that, quote, no freedman, free Negro, or mulatto, not in the military service of the United States government, and not licensed to do so by the Board of Police of his or her county, shall keep or carry firearms of any kind. Now, we don't have laws that are so explicitly race-based today, thankfully. However, the subjective may-issue laws that are in place in states like New York do end up having a disproportionate impact on Black Americans. For instance, there was a survey that was recently done in North Carolina, taking a look not at the issuing of concealed carry licenses, but the issuance of pistol purchase permits, because in North Carolina, this is another remnant of Jim Crow. In order for you to purchase a handgun, first you have to go to your local police chief or your sheriff and say, please, sir, can I buy a handgun? And again, you have to demonstrate your suitability. You may have to submit character references. Even if you're not a prohibited person, even if you've never been arrested before, county sheriff can say, I don't like the look of you, so you don't get to buy a handgun. And even though we now live in 2021 and the Jim Crow days are gone, the survey found that even today, in the Raleigh-Durham area of North Carolina, Wake County, which is one of the more quote-unquote progressive parts of the state, black applicants are almost 3 times as likely to be denied their ability to purchase a handgun than white applicants. I'll be very curious to see as amicus briefs file in with the New York State Rifle and Pistol Association case, whether or not there is any research done into the discriminatory impact of New York's May issue carry laws. Because I have to believe that, again, white applicants in New York State, far more likely to be approved for a carry license, far more likely to be able to demonstrate good cause or justifiable need to carry a firearm than black applicants. Now, again, I don't have the evidence right there in front of me, but we've seen this with other gun control laws in other states, and I just have a feeling that that is the case in the state of New York as well. So we're going to continue following this. There are a number of other briefs that have been filed, friend of court briefs that are already coming in. More are going to be coming in throughout the summer. And we'll be taking a periodic look at some of these and the arguments that not just Paul Clement making on behalf of the plaintiffs, but other outside groups arguing in favor of striking down New York's carry laws. And then, of course, the defenders of New York's carry laws are going to be weighing in as well over the course of the summer. So while the oral argument's not going to take place for a few more months, the actual arguments over New York's carry laws are already underway at the Supreme Court. All right, now let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Utah. And you can see the headline here, parole failure leads to death of Utah handyman. This handyman was a guy named Melvin Tony Martinez, and he was working at a home in West Valley City, Utah in May of 2020 when he was shot and killed. And according to Channel 2 News in Utah, the suspect in this case, a guy named Jesus Adolfo Valdez Jr., who was living next door to the home, should not have been there. That there were failures on the part of the probation and parole board there that, quote, mischaracterized the parolee and allowed him to return to live with his parents, who did not follow the conditions of his parole agreement, which they say led to the shooting. Martinez's mother-in-law said that he would still be alive if Utah parole agents had done their job and arrested Valdez Jr. after multiple parole violations. Channel 2 News investigated and says that Martinez may not have been killed if it were not for a series of missteps by the Utah Department of Corrections, Adult Probation, and Parole. Okay, so what exactly happened here? The board granted parole to Valdez Jr. 3 separate times. The last time, shortly before the death of Martinez. Karen Mooseman, who is Martinez's mother-in-law, said, we'd heard about the handyman on TV, but, it didn't even dawn on us that it was him. A department whistleblower said it was a, quote, truly tragic story, a story that never should have taken place, saying that Valdez Jr. had a violent criminal past, and it should have been no surprise that he would lash out again. Valdez Jr. had already spent several stints in prison because of violent criminal episodes. The whistleblower said, quote, Jesus had a history of threatening violent behavior. He's a violent guy who never should have been let out of prison. Murray police probable cause statement painted a portrait about the threats that he made to his ex-girlfriend. She had told Murray Utah police officers that he had been repeatedly contacting her, making threats from restricted numbers. She said she would sometimes answer and ask him to stop contacting her, but he wouldn't listen. May 16, 2018, she told police that he called him again, threatening her, stating things like, I'm going to kill you and rape your dead body, you stupid. Yeah. I'm going to kill your family and rape your dad, he told her. The statement also indicates that he told her he was on his way to kill her and the boys, and he wanted to get shot by police. Now, Valdez ultimately was taken into custody, But it didn't last long. He was granted parole on August 20th, 2019. He was in prison from August 29th, 2018 to August 20th, 2019 on a conviction of criminal mischief and threats of violence. Not only from threatening his ex-girlfriend, but also a case where he choked his mom, assaulted his friend, made death threats, and punched holes in the door of his parents' home. So he's already been convicted of violence against his own mother, right? And then they release him to his parents on parole, which seems weird to me to begin with. But according to KUTV, family members or friends of inmates who have agreed to have the offender live with them fill out this form that asks if the person will allow officers from the probation and parole board to visit the residence during parole. So yes or no answer that's required. Also ask if anybody in the residence is a victim of the offender. Valdez Jr., yeah, he accosted his mom. Also asked if there are any firearms or dangerous weapons at the residence. For that question, a yes or no answer is required. And apparently, those forms were not correctly filled out. When he was released on parole, he was specifically told not to have any contact with his mother without prior approval from adult probation and parole. Documents show that agents actually met with mom, checked the address, provided a walkthrough, and no issues were found. Well, issues should have been found because he's living with one of his victims. February 7th, 2020, agents returned to the home. They find alcohol in the home, which is another violation of his parole agreement. His mom was reminded about the no alcohol rule. March 16th, they visit the home again. They say that they found no issues at that point. April 9th, they went back. He wasn't there. May the 5th, they went back and talked to him again. 12 days later, they tried to find Valdez at home, but he wasn't there when they show up. May 28th, they were at Valdez's home. Agents note, quote, he's doing very well. And then approximately 4 hours later, Tony Martinez was dead. Police found the gun used in the shootings in Valdez's father's truck. The dad says that's where he kept it, and it did belong to him. He was actually taken to the police station, was asked if he shot the handyman because it was his gun. He said no, obviously. And then Valdez Jr. Was ultimately connected to the crime after Valdez Sr. admitted to buying the gun from a pawn shop a couple of weeks earlier and taking his son out shooting. Again, in violation of his probation and his parole. So there are, I think, plenty of warning signs here. This isn't a case of a light sentence on the part of a judge. This is a case of a failure of a state agency to properly monitor an individual under their care and supervision. And he never should have been released to his parents, given that he had already accosted his mom and had been convicted of that crime. He should have been returned to prison upon the first violation of his probation, but none of that happened. And instead, a man is dead. And of course, now Valdez Jr. Going to be spending a lot of time in prison as a result of that crime. All right, on to today's armed citizen story from Escambia County, Florida, where sheriff's officials say a teenager acted in self-defense in a fatal shooting outside of a home. 60-year-old man was shot and killed in Escambia County. Investigators say that the teen shooter will not be charged at this time because they believe that this was a self-defense shooting. The state attorney's office is investigating and will make the final ruling on this case. Escambia County Sheriff Chip Simmons says that the 60-year-old man who was shot thought that a pair of young men were trespassing and yelled at them to leave, but one of them actually lived at the home in question. So it wasn't a 60-year-old guy yelling, "Get off my lawn." It was, "Hey, get off that lawn." But one of the juveniles actually lived there. And apparently the two teens were getting ready to go fishing. At one point, Simmons says the man stuck his arm into the car that these kids were in, grabbing the driver by the throat and then choking him. Fearing for his life, Sheriff Simmons says the teen shot the man. Neighbor says she saw it all unfold in the driveway of the home. She said she saw the man pull up to the house, blocking the driveway. She said he then went up to a car with young men in it and started arguing with them. The woman said he then pulled into the street only to run back to the car, screaming at them. She said, "I was looking to see if he had something in his hands, for a weapon, and he didn't have anything in his hands, and he put the window down in the car, and he had his arm in the car, and then I heard 2 shots. Again, a lot of details that are still undetermined here. In fact, we don't even know how old these teenagers were. Were they 16? Were they 18? But we do know, again, it appears as if this was a self-defense shooting in Escambia County, Florida. We'll keep our eyes on any more details as they become available. But, it's interesting. We just had that court decision in Florida last week where a judge said, I'm bound by 11th Circuit precedent here in upholding this law banning 18, 19, and 20-year-olds from legally purchasing a firearm. I think that there's a real open question as to whether or not that's constitutional, but the 11th Circuit Court of Appeals has said that it is, so I have to follow their precedent. And here we have a case of somebody under the age of 21 using a firearm, according to authorities, to save his life and the life of another. All right, on to today's good deed of the day from Salem, New Hampshire. That's where we started our show in New Hampshire. I guess we'll end our show in New Hampshire as well, where a good Samaritan in the right place at the right time, willing and able to do the right thing to save the life of a young girl after a car crash. Scott Dimmers said he didn't have time to panic when a car came barreling through a home with kids inside. He said it was like a war zone. It was chaos everywhere. Now, Dimmers has no official medical training, but he still leapt into action. He saw a 5-year-old girl severely injured, bleeding, and in need of help. He jumped in. He was actually a couple of doors down fixing some outside sprinklers when he heard the impact of this car hitting this home. He said the father came out of the house screaming that he had just killed my little girl. I saw blood squirting out of her neck, so I knew that she was still with us. That little girl's father, Joseph Tutrone, said those who responded to his cries to help, they were the ones who saved her life. He said, I was a complete panic. I didn't know what to do. The 5-year-old, who again was, it sounds like inside the home and not in the vehicle, has a broken jaw, several facial cuts, but is expected to make a full recovery thanks to the quick thinking and quick actions of Mr. Diemers here. He says, I don't have the most inviting appearance sometimes. Heroes don't always wear capes. Mr. Diemers looks kind of like me. He's got the big bushy beard and he's got better hair than I do. But I will say this, Scott Diemers, not all heroes wear capes, man. Sometimes they just have a big old hair curtain hanging off their chin. And you, sir, in the right place, at the right time, willing and able to do the right thing, are absolutely a hero. And we thank you for your very good deed. Now, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being with us. As always, don't forget, you can become a VIP subscriber to Bearing Arms. All you have to do is go to bearingarms.com/subscribe. Use the promo code GUNS. Get 25% off of your VIP membership. It'll give you exclusive analysis, commentary, and more. You'll also get a chance to support programs like this each and every day, bringing you the latest Second Amendment news and information. Hope you have a fantastic weekend. We'll be back on Monday with even more of the latest Second Amendment news and information that you need to know about. Until then, be well, be safe, and be free.